Takes practice.
Okay, so today we're going to talk about credit reporting in the context of bank. Oh my God, now I'm flustered. Okay, sorry.
Deep breath.
Yep.
Shake them
Okay,
out.
we're good. All right.
Hey, it's okay
So
if you say
today we're going to talk about alternatives to bankruptcy. People will be inundated with phone calls. They'll be overwhelmed with believing that they have unpayable debts. Those are some of the driving factors that will cause people to file bankruptcy. They'll also think there's a situation where I can't possibly ever pay all this off. There are alternatives to filing bankruptcy. One of the things that you can do is negotiate with creditors. And so as we step through this, we'll think about why you might not want to file bankruptcy, why you may want to file bankruptcy, the origins of bankruptcy, where it comes from, and basically kind of looking at what are your overall financial options. So starting off, you may want to consider the fact that bankruptcy isn't the only option available to you. What are some other options available? So first of all, there's negotiation with creditors. And you might want to negotiate with creditors because if you file bankruptcy, that's on your credit report from 7 years from the date of filing, okay? So how does that differ from negotiating with a creditor for a timing perspective for how long these debts are going to remain on your credit report? If you negotiate with a creditor, you might have the situation where you have an account that charged off, say, 5 years ago. You negotiate with that creditor, and as part of that negotiation, they agree to not refurnish information or restart the statute of limitations for a credit reporting perspective. That can all be worked out through a conversation, but you have to be very careful because if you pay a debt, which this is just one of these bizarre situations, by making a payment on a debt, they'll try to incentivize you. Hey, if you make a payment, we won't sue. If you make a payment, we'll stop calling you. If you make a payment, we will look at some other alternatives and we might not continue credit reporting. You have to be very careful about falling for that trap because a single payment reaffirms the statute of limitations on that debt. So if you have a contract with somebody, you failed to pay under the contract, so this would be an example, this would be like a credit card, a bank loan, a car loan, etc. You fail to pay that, they have 6 years in the state of Minnesota at least to sue you on that contract, okay, from the date of charge off. So the date you default, the date that you cease to pay or meet your obligations under the contract, you have 6 years in order to bring a case. Outside of that 6 years, they can never sue you for it. They can still credit report now under the FCRA for an additional year, right? So it's 7 years under the FCRA, 6 years for actually being sued. So there's a weird 1 year overlap where you can't be sued for it. You know, the debt is not going to affect you from a legal perspective, but they can still actually just report to potential creditors that you owe that debt. So there's kind of that weird gray area there. But the point being is you have to be extremely careful on making that payment because if you make that payment, it restarts that statute of limitations. That 6 years then starts over, which is just crazy when you think about it. So let's say that you have a 2010 car loan, right? In 2015, they call you and they say, it charged off in 2010, just make one payment, we won't sue you, and we'll go on from there and we'll see what we can work out after that. You make that payment, they can now sue you for an additional 6 years from, say you make it in 2015, so it's 2021 today, they can still sue you today back from a 2010 charged off car loan. You gotta be careful on that. So, one, negotiations, you have to know what you're doing when you're negotiating. Bankruptcy is a hammer. It's a big tool that gets the job done, right? There are better tools that can be used, but you have to be careful. And that's why I would highly recommend talking to somebody who practices in this area. There are a variety of scams out there, and you have to be very careful about debt consolidation or debt negotiation. There's a variety of private companies that do this. They're not attorneys. They're not They don't necessarily have the same ethical guidelines that attorneys are required to follow. And as a result, be wary of those companies. But there's certainly, I know here at Minnesota Legal Assistance, we'd certainly help with this type of situation. So, contact a legal aid organization or other nonprofits, such as consumer finance education deals that will also help people to negotiate out of situations like that. So do your homework on whether or not it's a trusted organization before engaging them. But that is at least one option for an alternative to bankruptcy. So why would somebody file bankruptcy in the first place? There can be a variety of reasons, right? So you can have nonstop calls, for example. So somebody might be suffering from, so you might just be suffering from harassment, right? Somebody might continually be calling your house. You might have a variety of creditors calling your house, making threats, calling the workplace, etc. So that might be one reason. Another reason somebody might file bankruptcy is that they are facing the threat of a lawsuit by a creditor and cannot find an attorney to represent them or legal services to represent them. Another situation that might cause you to file bankruptcy would be just a desire for a fresh start. You're just overwhelmed by the amount of debts and how they're spread out and not being able to tease through it all. So you get that overwhelming situation. You might also desire to file bankruptcy because under Chapter 7, it gives you a totally fresh start. So it wipes everything out. You may actually notice a credit score improvement from filing bankruptcy, believe it. So basically, what are some alternatives to address these particular situations, right? So harassment, okay, this is where a debt collector is calling your house, or maybe even a potential creditor is calling your house or workplace. There are federal consumer statutes that prevent them from contacting you if you so state. So you send them a cease and desist letter. Hey, I cannot receive phone calls at my place of work. That can put a stop to it. So that's an alternative to bankruptcy. You don't necessarily need to file bankruptcy to stop that. There's another situation where, let's say they're calling your house, right? You can send a cease and desist letter. Do not contact me again about this debt. They are free to continue credit reporting, so that's an alternative that might not address everything. But if harassment is your sole purpose, again, another reason, FDCPA, you send them a letter, say, hey, look, I can't be contacted at work, don't contact me at home, cease and desist entirely, stop calling me on my cell phone, only send me letters. Those are some options, right? Those are options available to us. A lawsuit. One, contact there's a variety of consumer attorneys that can help in defending people against lawsuits. Oftentimes, the creditor bringing the lawsuit will come completely unprepared to court. These things are filed en masse, in a way that is litigated, frankly, in a reckless way. They have no witnesses. They typically show up in conciliation court with an attorney and a piece of paper that purports to have your signature on it. There's a very real defense to that lawsuit. Number one, is the attorney acting as the witness in that case? Who's admitting the document, right? Anybody else would laugh at that. If you came into court and you said, I don't have my client here, I've got this stack of documents, I have no witnesses to admit them, but I plan on winning this lawsuit, you would be laughed out of court, if not sanctioned by a judge, because you would be totally unprepared for your case. Yet these cases go through conciliation court all the time simply because people don't show up. So showing up, making an objection, and saying, hey, look, that document right there, I object to its entry. It has no foundation. It has, so these are somewhat esoteric legal terms that you might not be familiar with, but you can educate yourself online, and I think that a lot of people could probably win these lawsuits, provided that the conciliation court judges are willing to look at the law and follow the rules of evidence, which is questionable at times. But nonetheless, and we can go into that later, but nonetheless, simply showing up and defending these lawsuits, it's an option. Or you can hire somebody, you can go to a nonprofit. There are a variety of options to be able to push back against those lawsuits. Finally, there's just, you're overwhelmed. Just because somebody's overwhelmed, I would say it is a reason, and it's an understandable reason, but there are other options available to you. Talk to a consumer finance education program. Sit down with somebody and try to get the debts listed out. It takes time and it's a painful process. But if you do that, you might be less, one, overwhelmed, you might be more organized, you might figure out what you're actually facing, and it might not be what you think it is. And you might be able to use some of these other tools very quickly to say, you know, actually, when I look at this, there's only 2 or 3 debts of it that I'm dealing with, but I'm being contacted so much, it feels as if there's so much more. The next thing that I'd want to talk about is types of bankruptcy. Let me first say, I don't practice in bankruptcy. I have done bankruptcies, but I'm not an expert in bankruptcy by any means. At Minnesota Legal Assistance, we do not currently do bankruptcies, and there's a variety of reasons for that. There are a lot of low-cost providers, and bankruptcy is something that courts contemplate people being able to file who don't have a lot of means. So we think that there's a lot of resources out there, so we're just not targeting that area currently. But let's just talk about the different chapters of bankruptcy and how the bankruptcy code functions. So they're mainly for consumer purposes.
She said you have to shake it.
Just don't mind me. Okay, so let's talk about the different chapters of bankruptcies that a consumer might come in contact with. So this is differentiated from a business, right? A business is going to file chapter. Let's not even touch on businesses. What is a consumer going to file? Typically, they're going to file a 7 or a 13. Farmers and some other entities may file something called a chapter 9, but typically a consumer is going to file under either 7 or 13. Okay? So how are these differentiated? 13 is if you want to retain property. Okay? A 7 is something referred to as a total liquidation. So the bankruptcy code provides something called exemptions. The exemptions provide you ability to keep certain things. I believe in Minnesota, it's a car under a certain value, a chunk of equity in your home, personal goods and belongings, memorabilia, these types of things. So filing bankruptcy doesn't mean a total yard sale of everything in your home. There's all sorts of exemptions and all sorts of things you keep. Generally, they're looking for large saleable items that you have equity in under a 7, and they want to take those items so that they can liquidate those items, but those items, again, have to have equity. So if you have a car loan, for example, you just purchased a car, and that car is worth $20,000, and you have a $21,000 loan on it, you're underwater on the car loan, that typically is going to be of very little interest to a bankruptcy estate or a trustee. And in fact, you can get out of that loan by handing the car back. That's secured property, so you'd give the car back to the bank, or you can do something called reaffirming. So you can say, although I'm filing bankruptcy, I actually want to keep this car, and therefore I'm going to reaffirm the car loan. Now, there are certain requirements, such as being up to date on the payments, and there are other situations where you catch up on the payments, etc. If you're behind on the payments, you have to bring the loan current, unless you can negotiate. Sometimes you can negotiate in the bankruptcy estate and say, hey, look, let's just restructure this loan, and there can be all sorts of ways of doing that, and that's got a negotiation component to it as well. 13, by contrast, is if you have a lot of property that you have equity in, but you just can't meet the payments. And rather than wiping somebody out entirely, this allows you to retain that property, in some cases cram down the value of the property, the value of the loan to match the value of the property, because that's all they would have gotten at sale anyway, and then allows you to structure all of your debts together at a lower interest rate over a longer period of time, overseen by the court system until you complete your payoff plan for your Chapter 13. These are going to report on a credit report actually roughly the same. A 7 is going to be on your credit report for 7 years from the date of filing. A 13 is going to be on your credit report for 7 years from the date of filing as well. There was some confusion on whether or not a 13 would remain on your credit report during the payment period, but it is actually under 7 years from the date of the filing. So that is a clarification. So let's talk about how a 7 or a 13 is going to factor onto your credit report. First of all, at the date of filing is how this is reported. So it doesn't matter if you go through the full 7, if the 7 gets dismissed, if the 13 gets dismissed, you later pull the plug and say, hey, I actually don't want to declare bankruptcy. You have declared bankruptcy, you have filed something with the court, that is going to be on your credit report. And a corollary to this is, if you file, you have to be very, very careful. Because if you screw something up and it gets dismissed and they have to refile it, guess what? You have filed bankruptcy twice. That's huge. That means it reports on your credit report as filing bankruptcy twice. You have to have stuff right. You have to be sure what you're doing. This is a big decision to declare bankruptcy. And when you see, bankruptcy advertised at $500 out there, you have to be careful. You have to be careful because it is not a $500 decision. It is much more than that. It's going to remain on your credit report for years. It's a court filing. It is a public filing. It is a matter of public record. So you need to consider more than just the price. You need to look at the overall perspective. And I'm wary of $500 bankruptcy practices because the question is, do you sit down and do you actually explain what is going to be the impact of doing this? And you need to have a lot of discussion on the front end before you commit. It's not just, hey, I read on the internet that filing bankruptcy is a good thing and therefore I want to file bankruptcy. A proper attorney, somebody educated in this area, a practitioner in this area, should sit down with you and say, hey, look, I'm not just going to take your money to file bankruptcy. We need to have a discussion. We need to figure out if this is the best route for you to go. And there's a variety of reasons one does not want to file bankruptcy, even though they have a ton of debt. So one of those things that I would wish that people would talk about before filing a bankruptcy is those alternatives to filing bankruptcy. So let's say you're thinking about filing a total liquidation bankruptcy, a Chapter 7, and you're filing it because you're getting calls at work. Your boss says, look, you've got a ton of debt, you need to take care of these things, you can't be receiving those calls at work, and if this continues, I'm going to fire you. That's a possibility. I've heard situations where that's the reason that somebody decided to file bankruptcy. That is a terrible reason to file bankruptcy. Why is that? Because you need to have the conversation with the boss. All right, who called, when, what is this? We don't even know if this is a valid debt, number one. If it is a valid debt, there are alternatives. We can contact that creditor and we can say, you cannot call me at work. Cease and desist all communication. I cannot receive phone calls at work about this debt. Here's a different way to contact me. Or don't contact me at all. You have a right to do that. Another reason somebody might file a Chapter 7 bankruptcy is that they're receiving tons of phone calls at home. So this situation isn't limited to work. You can also say, don't call my house. Don't call my cell phone. Don't call anybody associated with me, okay? Another reason somebody might file Chapter 7, my mom keeps getting phone calls on her cell phone about my debts and I gotta take care of this because now my family's upset with me. It's not a reason to file bankruptcy. There are other consumer statutes which specifically say you can't contact a third party as a debt collector. So you need to know, one, who's calling, what they're allegedly calling about, and you need to factor those decisions in to your decision to file bankruptcy. And this is all discussion that needs to happen prior to making that decision to file bankruptcy. Another thing, I'm a victim of identity theft. I have to file bankruptcy. Terrible reason to file bankruptcy. Terrible. I don't care what's on the credit report because you currently, if you're a victim of identity theft, have a bunch of false information accounts that you are not responsible for due to identity theft, and you are about to commit to a Chapter 7 bankruptcy, which is a actually valid thing that you did, and that ain't coming off your credit report because you filed it. You actually did that action. So now you've taken something where you have false information on your credit report, and you've replaced that now with a valid, true information that's just as derogatory and going to cause you the same or similar problems with regard to your credit report. So you don't want to file bankruptcy because you're a victim of identity theft. So, our approach is we're going to start at the credit report level, because I think that is I think they do a good job, at least, of in situations where there are valid debts. That's a good starting point to figure out what exactly is going on here. That's kind of the template for starting that process. Now, you might have people calling you that are not reporting on your credit report, right? And you might have people reporting on your credit report that are not calling you. So you see, the data is not always perfect. And because of that, I think it's really important to take a step back from it, realize, okay, the answer isn't just bankruptcy. It may not be just suing a harassing creditor. There might be a composite, a larger picture. And then what we do, I think, at MLA is we're going to refer some of this stuff out to a consumer education nonprofit. Now, these exist all over the place, and they're actually required for you to visit a consumer education nonprofit or consumer education organization prior to your bankruptcy being finalized. And one of the things that they're going to do at that organization is they're going to lay out your debts. They're going to lay out your assets. They're going to make you create a financial plan anyway.
Right.
So, hey, how about doing that on the front end and using that as a tool to make the determination of whether or not you need to file bankruptcy?
Get the actual timeline of how long that's going to take.
Get the data beforehand.
That was probably the most beneficial part of me filing bankruptcy is
Totally.
I saw everything.
You're gonna, exactly. You're gonna be doing it either way, so you might as well do it on the front end and use it as a tool to figure out, do I actually need to file bankruptcy? Because I am shocked by the number of times I hear, I have a past due car loan, they won't stop calling me, credit acceptance is just blowing up my cell phone, and that's why I filed bankruptcy. That is a terrible reason to be filing bankruptcy. A terrible reason. I have 12 creditors suing me. Maybe a better reason. One organization is calling me. It takes a 5-minute letter to take care of that. So the key is you've got to know what you're dealing with prior to making a decision about your legal future or your financial future. And the first step in that is going to be creating that financial plan. You come to us, we're going to first pull the credit reports and use that kind of as a baseline and start that conversation. We've got great referrals for places we can send you to make a more detailed financial plan. But overall, we're going to need a financial plan, we're going to need a credit report, and we're going to create a plan based on that. And look, our recommendation at the end of the day might be file Chapter 7. That definitely comes up. Right? There's a reason that exists under, it goes back to the Constitution. Bankruptcy is in the Constitution. It's very interesting. It's Article 1 of the Constitution. So, Congress certainly contemplated a variety of options by establishing all these consumer laws. And it's kind of a shame that the legal system has kind of dealt with it to date in one way, which is file bankruptcy. There was a recent paper I saw that came out that talked about some of the inherent problems with credit reporting in America and how they're disincentivized because credit reporting or initiating a suit against a creditor, a national consumer reporting agency or somebody who's furnishing information to a credit report, because that requires such a detailed process, it actually disincentivizes following the rules. It creates huge problems, and more consumer complaints are happening each year. I saw there was over 125% increase in consumer complaints dedicated to credit reporting with the Consumer Financial Protection Bureau year on year in between 2018 and 2020. So just fascinating that you're just seeing more and more of these complaints happening. Number one. And another interesting statistic that I saw within there was that almost 60% of the complaints lodged with the Consumer Financial Protection Bureau were over credit reporting. It's not calls to cell phones. It's not robocall. It's credit reporting. So this is a massive problem in this country. Almost every American at some point who has an established financial footprint in this country will have some kind of an issue with their credit report at some time. So this is a huge problem, and it is a complicated problem, but tools other than bankruptcy exist, and it's critical to understand what options are available. The payment plan bankruptcy, you may find that somebody contemplating a payment plan bankruptcy is better suited to that tool. Typically, people filing a 13 are doing it for a reason. They've got a substantial amount of property that they need to cram down the value on or readjust their loans so that they can actually meet those obligations. So there are fewer tools available, I would say, to somebody contemplating that 13 for the right reasons. But again, even that discussion needs to be had on the front end. The person contemplating the 13 should still come in and at least look, are you contemplating a 13 because you're actually being harassed by one of your creditors, and now you're thinking about restructuring your entire financial future over one defaulted loan that we might have tools available to address. So, total liquidation, I would say don't even consider this without looking at the other options. The 13, certainly you need to be looking at what other options are available. Again, we're here to help. One of the first things that you're going to do is make that financial plan and reach out. So when we're looking at bankruptcies in-house, what we've got to do is, number one, you're going to see it on the credit report as just this person filed a chapter 13 or a chapter 7 or whatever on this date. So you're going to see that, and you're going to check that date and make sure that they're not re-aging that account. Re-aging, what does re-aging mean? It means taking something that was filed in 2015 and then they say that it was 2019, so it stays on the credit report longer. You'll see those errors all the time. But where we're really going to pin down that information is we're going to look at those individual trade lines, okay? And bankruptcies in particular are going to have major issues with these trade lines. We see it all the time. So what you're going to notice when you're looking at these trade lines is you're going to say, that's weird. The account charged off in 2010, let's say, right? I filed a chapter 7 in 2014, okay? And so they're going to re-update that account with furnished information in 2014. What do I mean by furnished information for the new people real quick? Furnished information, the way that we have this drawn out is this is the CRA. Sometimes this is referred to as an NCRA, a National Credit Reporting Agency, or Consumer Reporting Agency rather, okay? You've got your creditor here who furnishes, is the term, furnishes information to the CRA. The CRA then provides a copy of your credit report to your potential creditor, okay? So, and then you obviously can request a copy of your report from your, from the CRA, but this is the furnisher / creditor, right? The furnisher will provide something on your credit report called a trade line. So when you look at your credit report, it will say credit acceptance. Okay, you have a $15,000 past due car loan, right? So that's that little chunk on the credit report, right? Well, let's say that this bad boy charged off in 2010, okay? When you file bankruptcy, they'll update this, and in 2010, right, is when it charged off, so it should be aged from 2020, but when you file bankruptcy, it prevents them from suing you on this, right? And they'll update this information. They'll update it and they'll say, charged off bankruptcy. And then they'll update the date from 2010 to 2014. Okay, we're looking at that, so we're talking to the clients and we're saying, hey, when did you make the last payment on this? And they'll say, well, I made the last payment in 2010, not 2014. So what happened here? Well, they furnished new information, they updated the date, and that credit acceptance now, which would have dropped off, is now going to stay on for 7 years. Would have dropped off in 7 years from 2010, so 2017. Now we've got 7 years from 2014, 2021. So that right there is something we can catch. So if we're looking at this in 2020 or 2021 now, and it charged off in 2010, okay, we've got a problem right there. That shouldn't be on the credit report at all. Chapter 7 doesn't mean that you're reaffirming debts and somehow your charge off changed. It didn't. So that was delinquent then, and it's delinquent after you file bankruptcy just the same. And they do not get to re-age that information. So you're going to see that all the time. And that's going to be the dispute letter that we send out that says, hey, look, this is not charged off. This thing it's not charged off due to bankruptcy. It was charged off due to non-payment in 2010. Correct the information. They're going to look at it. They're going to be confused, and they're going to inevitably not update anything. They're going to say that the dispute is verified, and the next thing you know, we're going to be sitting there saying, great, we've got another lawsuit. So we're going to be able to bring lawsuits for each of these trade lines. So we're going to go through those credit reports, find those things. Re-aging, that's going to be a huge target for us. The bankruptcy date generally is generally going to be correct. I don't see those off very often because it's coming from the court system, and the court system is just better at what they do. So you're generally not going to see those. You're going to see it in the trade lines. So that's where you need to be looking for those bankruptcies. Another thing you might see is multiple bankruptcies. You're going to have people say, well, I've got 2 bankruptcies on my credit report, but I only filed it one time. More than likely, something got screwed up, and guess what? You actually filed bankruptcy twice. It would be very rare that the court record would reflect twice if you had only filed it once. It means somebody screwed up somewhere, didn't tell you, and it actually got filed twice. Or they told you, or you pulled the plug, said, look, I don't want to do this, and then went back and did it again. That actually is going to reflect as 2. And they're going to stay on your credit report, even though you're dealing with the same debt. It's going to stay on the credit report 7 years after the filing of the latest one. So the first one may drop off, but you will still have a bankruptcy until that second one drops off. So it's a serious concern. But us as our team, we've really got it. When we're looking at bankruptcies, we're still looking at the trade lines. We're not looking at generally speaking, we're not looking at the individual. But hey, look, we're gonna get people in big time that have situations where they've got somebody else's information on their credit report. So this is what's referred to as a merged file. If Tommy pulls his credit report and my accounts are showing on there, let's say he has a similar name to me, that happens all the time. It's a huge problem. One of the big verdicts that happened on this was done by a buddy of mine. It was $31 million out of Oregon. He sent the thing in and said, hey, look, this person's information is incorrect. He then made a demand, I think, for like $300,000 or due. So this person had somebody else's information. It was called a merged file. They have somebody else's information on their file. What ultimately happened was they got turned down for a mortgage as a result of this, okay? Turned down for a mortgage, they lost their dream house. We can imagine that would really suck. And what ultimately happened is they said, fine, we're gonna sue you. This is crazy. They sued them because they refused to take the information off. They sued them. They made a demand, I wanna say it was like $300,000 or something, because they're pretty upset. And Experian and Equifax said, pound sand, we are not paying you. We're not paying you anything close to that. We'll pay you like $5,000 or something. They're like, no, I lost my dream house. And even the lawyer's like, I don't know, maybe we should settle, maybe give them like, $50,000 or something, right? And at any rate, they went through the whole trial, and the jury was just pissed in the end, I think. And they ultimately awarded, I think it was like 31 million, which is crazy, yeah. But here's the legal system, lest any of us think that the legal system is out to stick up for the little guy. They took the jury verdict, what a jury decided, 12 people off the street, the people that are actually supposed to determine this, and the appeals court crammed that back down to something like 6 million. So they took away 30 million that the jury gave somebody and said, no, that's too high. and then we pushed it down to like 6 because God knows Equifax couldn't afford $31 million. I mean, it's asinine. Like these judges have no concept. They're like, they don't realize that is a rounding. 31 million is a rounding error for Equifax. I mean, that is nothing to them. Thanks, guys. Thanks for watching this. It's really important that if you gained knowledge or value from these videos, that you hit like. The point of what we are doing is trying to educate consumers and trying to work together as consumers to push back an industry that really holds us down. So it's super important that we get this information out to other consumers and that we work together. And this is a huge part of doing that. Thanks so much. Thanks, guys.
No, we're on this one.
Yeah. Oh, yeah. Sorry.